All right. So Mr. Lloyd, go ahead.
Thank you, Mr. Chair. Yeah, this amendment came forward. You know, I was speaking to some of the National Women in Law and other groups earlier on when we were going through this bill, and there was concern expressed because protection orders are usually decided by consent between both parties. And there was concern that if we pass too heavy-handed of laws that say you must revoke a license, you must do all these things if somebody has ever been subject to a prohibition order, that would actually result in more contested hearings over protection orders. And certainly we wouldn't want to increase the contestation of these prohibition orders. I think having them mostly consensus-based is a positive thing. And so I think, and sometimes the situation, they're very fluid, so I believe that we need to trust in the discretion of our chief firearms officers and the Canadian Firearms Program to determine whether somebody who has previously been subject to a protection order, whether or not they truly are a threat to public safety. And so I think that this has merit. I want to talk to, the Chief Firearms Program or one of the witnesses that might know some things about this. Generally, when somebody has been subject to a protection order, that's something that comes up in the screening process. Is that not true? And you have to do, what process do you do? I apologize if you've already explained this, but what's your process for, is it a balance of probabilities? How do you determine whether or not that is a barrier to somebody getting a firearms license?
You are correct. The Chief Firearms Officer would be made aware of protection orders against an individual through the courts. And the CFO under Section 5 would take that element and any other element that they would have to investigate the individual's eligibility to hold a license. So, I mean, I can't speak to the exact details of what the protection order would have made the CFO decide to take an action against somebody in holding a license, because the protection order information would vary.
To clarify, I'm not talking about people who are presently subject to a protection order. This is talking about people who were previously subject to a. Is that information shared with the CFOs? When somebody's applying for a license, or they're getting their license renewed, that they were previously subject to a prohibition order or a protection order, or protection order?
I don't know, actually.
I guess that's something you generally have to disclose, if I can remember the form right, but.
Yeah, you are correct, actually. I think there are personal history questions on the application that ask the individual if they have been previously subject to a protection or a restraining order.
Do the CFOs, is it general practice to grant these licenses to people that have been subject to a protection order, or does it vary?
It would vary based on circumstance.
But in general, in practice, what's your experience?
I can't generalize on an answer to that.
Okay. Thank you. How much time do I have left, Chair?
1 minute, 24 seconds.
Yeah, so I just want to reiterate, it was raised to me by a number of advocacy groups that because protection orders are usually decided on a consent basis, that by introducing this, it could have a negative consequence in terms of making people fight these protection orders at court and making it a much more adversarial process than it needs to be. Generally, I think we should trust the discretion of our chief firearms officers and our able civil servants who obviously have an interest in protecting the public and ensuring that people who are truly a danger to society don't have access to a possession and acquisition license. And so I think that this is a positive amendment that everyone can get behind. Thank you, Mr. Chair.
Thank you, Mr. Lloyd.